Good afternoon, everyone, and welcome to the 39th Annual John S. Bainbridge Moot Court Competition. My name is Alessandra Albano, and I am the Editor-in-Chief of the Toro Law Moot Court Honors Board. While this year has been anything but ordinary, we are proud to present this event in person for the first time in 2 years. With the aid of my extraordinary colleagues, advisors, and the Office of Administration, this event was made possible. We are honored to have our esteemed judges, the Honorable Mark D. Cohen, Mr. Dorian Glover of the Nassau Bar Association, and Mr. Daniel Tambasco of the Suffolk Bar Association, here to help judge the competition. We are also honored to have our 2 finalists, Laura Riano and Ashley Traviglione, here competing today. At this time, I would like to introduce the Dean of the Law Center, Dean Elena Langen.
Thank you, Allie. And welcome to all of you. We're so glad to see you here in person as opposed to on Zoom, which was the way we all watched it last year. As Allie has said, this is the 39th Annual John C. Bainbridge Competition. John Bainbridge, for those of you who don't know, is a former dean of the law school, one of the very first, and students honored him by naming this competition after him. You really have a wonderful panel of jurists today. Judge Mark Cohen is a retired judge, and he is our distinguished jurist in residence. And in addition to having been former president of the Nassau County Bar Association, Dorian Glover is also a Toro Law alum, and he is also an adjunct here. So we have some wonderful representation from Toro people. And of course, we have the Suffolk County Bar Association president, Daniel Tambasco. Obviously, we are the Suffolk County Law School, so we're very happy to have him here. I want to congratulate both of the finalists. You had a tough competition. It is a great problem that you're dealing with. It's very cutting edge. Congratulations to the Moot Court Honor Board for coming up with this problem. Congratulations to their advisors, Professor Pocock and Dean Berman. Is she in the back? There she is, who have worked with these students throughout their time in the law school for being able to present this competition. All of you 1Ls, watch carefully. You will be doing an oral argument at the end of your first year in law school. So pick up some pointers now. Next year, when we come back for the 40th Annual John C. Bainbridge Competition, I expect to see 2 of you as finalists in that competition. So enjoy what you're going to witness today. Strive to be as good as the competitors that you will see today, and have a wonderful afternoon. Thank you.
Thank you, Dean Langen. As most of you have seen in the program, this is an 8th Amendment problem dealing with cruel and unusual punishment. For all those who know, this is a very interesting amendment to argue, and we have before us today a transgender inmate who requested sexual reassignment surgery, and it was denied by her prison facility. You will now hear today arguments for both the prison facility and for the respondent, June Osborne. Without further ado, I present to you the final round of the Bainbridge competition. Good luck to you both. Bailiff Cavallas, you may proceed.
All rise. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
First case on our docket today is Gilead Correctional Facility in Fred Waterford. They are the petitioners, and the respondent is June Osborne. May I hear the attorneys who are representing first the petitioner? Ms. Riano, thank you. And for the respondent? Thank you very much. The respondent may proceed.
Good afternoon, Your Honors, Mr. Chief Justice. May it please the Court. My name is Laura Riano, and I represent petitioners Gilead Correctional Facility and prison warden Fred Waterford. I would like to reserve 1 minute for rebuttal.
Yes.
Would the Court like a brief recitation of the facts?
I don't think that would be necessary. You can move on to your argument.
This case is about whether petitioners fulfilled their arduous task of balancing respondents' health and safety with providing sufficient medical care to address her needs without violating the Eighth Amendment. This court should reverse the decision by the Court of Appeals for the following 2 reasons. First, respondents' preferred method of treatment is not necessary because there are alternative treatment options available to address her medical need. And second, petitioner's chosen course of treatment was not reckless in any way and does not give rise to the level of deliberate indifference. As to petitioner's first point, to establish an Eighth Amendment violation, a prisoner must satisfy a 2-pronged test. First, an objective prong that shows proof of a serious medical need, and second, a subjective prong that mandates a showing of deliberate indifference to that need.
Ms. Riano, what case is that from, please?
Your Honor, the subjective test comes from this court's case, Farmer versus Brennan, and the objective test comes from Kozliak versus Spencer First Circuit case.
Thank you.
Petitioners recognize that gender dysphoria constitutes as a serious medical need. However, sex reassignment surgery is not required to treat that need. Fifth Circuit case, Gibson versus Collier, states that prisons do not have to provide whatever care the inmate wants. Rather, only medical care that is not so unconscionable as to fall below society's minimum standards of decency.
Counsel, if I may, there seems to be a query as to whether or not this is a life or death situation for June. How would you answer that?
Your Honor, treating just gender dysphoria is a process. And there were 2 doctors that assessed respondent, one who advised for sex reassignment surgery, stating that it may be the only option left to treat her, but Dr. Putnam disagreed with that. So because there are other alternative treatment options on the table that are still in the process of treating her, petitioners would not constitute this as a life or death matter this present moment, Your Honor.
Thank you.
Counsel, what are the alternative methods that were proposed?
Alternative methods include increased hormone treatments, increased one-on-one therapy sessions, which the respondent is receiving at this present time. In addition to that, several accommodations such as the ability to sleep alone, to wear female undergarments, shower alone, and the ability to receive a cosmetic treatment of body hair removal treatments, Your Honors.
Has the prison authorities, have they granted some of these?
Yes, Your Honor. All of the accommodations and treatments that I just listed are all of which respondent is currently receiving at this present time.
So they have provided all of the alternative measures that you're talking about,
Yes, Your Honor.
with the exception of course, the declination to provide SRS treatment.
Yes, Your Honor, because subsequent to respondent showcasing these symptoms of gender dysphoria was when she began to receive the 2 assessments by the 2 different doctors and the accommodations and additional medical treatment.
But moving past, most respectfully, the assessments by these doctors and the experts who testified, the question by Justice Glover was, in simple words, is this a life or death situation? In other words, we have this respondent who is literally at the end of the road medically.
Yes, Your Honor. That is why she is being monitored. Her hormone treatments are being increased, and that is why there are increased one-on-one therapy sessions to assess how she is reacting to that adjusted medication, Your Honor.
So does the government, that is, the petitioner, concede this is a life or death situation?
We do not. We concede that this is a serious medical need. We just do not agree with the method of treatment that respondent is in preference of. Respondent was assessed by 2 doctors, Dr. Blaine, who assessed for sex reassignment surgery, and subsequent to that, petitioners obtained a second opinion by Dr. Putnam because Dr. Blaine said this may be the only option left. It wasn't definite. And Dr. Putnam assessed against sex reassignment surgery for a variety of reasons. First, sex reassignment surgery is highly controversial in the medical community. There are several well-respected doctors that simply do not agree with this assessment, particularly because there is just not enough research to support how a transgender incarcerated woman would react to this surgery versus a transgender non-incarcerated woman due to the nature of prison life. Further, if respondent were to receive this treatment, she would be transferred to Red Lake all-female facility, particularly where female inmates have been victims of sexual abuse and assault. And if they are aware that a biological male is present, it'll raise issues to their psychological and mental health and affect the overall community of prison life.
Do we have anywhere in the record how many transgender inmates there are within first the federal system? There is some literature on this.
Your Honor, the record does not reflect the exact amount of transgender inmates that are present in this facility. But we do know of respondent June Osborne, and because of her being a transgender female, she is receiving those accommodations to remove her from any other potential risk that may be targeted towards her, Your Honor. Additionally, although the WPATH standards of care does assess for sex reassignment surgery, it also states that transgender individuals would be able to proceed and live a normal life without obtaining this surgery, Your Honors. Fifth Circuit case Gibson versus Collier states that medical professionals of a prison have no duty to provide the care that is most desirable to the inmate. Prisoners only have a right to obtain the best medical treatment option available. Do not have a right to obtain the best medical treatment option available, only sufficient medical treatment to care for them. And Your Honor, in referencing First Circuit case Kozliak versus Spencer, that case mirrors this case. Both were transgender inmates, both showcasing symptoms of gender dysphoria, and both were assessed by two different doctors. One who assessed for sex reassignment surgery and one who assessed against it. And the court held that selecting one of those treatments over the other does not give rise to an Eighth Amendment claim. And that court holds the same precedent that this court holds.
So back to your initial point about objective criteria and subjective criteria under Farmer and Kozliak, what is it that you say, objectively speaking, has been the department's and the individuals' efforts to mitigate the medical concern presented by the respondent?
Your Honor, I just want to ensure that I'm understanding your question correctly. You're asking what measures petitioners have taken to address this serious medical need.
Yes, and you've told us about the measures. And are there any other measures you can do short of what you've told us?
Your Honor, these are the only available measures at this present time because it's not realistic to put this inmate, to take this inmate out of yard time and meal times. We are discussing somebody who was convicted of third-degree murder and is required to serve out her sentence. And further, if we did put her in her own private facility for 24 hours a day, that could possibly constitute as to an Eighth Amendment violation of cruel and unusual punishment. These are the best effective measures that are being taken at this present time, Your Honors.
So subjectively, you're saying what?
Subjectively, we're saying that petitioners' chosen course of action does not give rise to a level of deliberate indifference. And that leads me to my second point, Your Honors.
Before you go to your second point, I have a question regarding knowing the risk that's involved here for June. Are you aware of the risk of not having this surgery for her?
Yes, Your Honor. The risk...
Or for June, pronoun.
Yes, Your Honor, but it would be difficult to say until we see how she reacts to these adjusted hormone treatments. That is why we have to proceed with this option first and the increased one-on-one therapy sessions to see how she's reacting before we can say whether we should proceed with alternative methods of treatment.
So you're saying right now that you might go for the surgery, but you're asking the court to delay this process so you can do a better study to see the need for this surgery?
Not in entirely, Your Honor. Petitioners have faith in the assessment that Dr. Putnam.
That's not what you just said there, though. You said you wanted to reevaluate in this moment.
Your Honor, it's not about reevaluating. It's about monitoring this inmate and seeing how she is reacting to the adjusted hormone treatments and the increased one-on-one therapy sessions to see how she's reacting to them. It's difficult to say without having that happen first, Your Honor. As to petitioner's second point, this court's case, Farmer versus Brennan, decided in 1994, defines the second prong of deliberate indifference as falling in between the scale of negligence and recklessness and holding it equivalent to reckless disregard. There is nothing in the record that reflects that petitioners were either negligent or reckless. Negligence is when officials should have been aware of the creation of a substantial and unjustifiable risk. However, the record clearly reflects that respondents were aware, they treated the inmate, and they continue to treat respondent.
Counsel, wasn't she still getting abused?
Your Honor, the record reflects on the timeline on pages 2 and 3 of the record showcases the timeline. She was sentenced in 2015. Subsequent to that, she did receive the abuse, and subsequent to her expressing that abuse was when she was assessed by the 2 doctors and provided the accommodation.
But that abuse continued even afterwards, did it not?
The record does not reflect that, Your Honor. The timeline states that she was sentenced, she received the abuse, she received the 2 assessments by the 2 doctors, the increased hormone treatments, the increased therapy sessions, and the accommodations.
Remarks by the guards?
I'm sorry?
What about the remarks by the guards?
Your Honor, page 5 of the record does reflect that respondent was acting aggressively towards the guards and breaking several rules. And while petitioners do not condone any type of teasing that may have been expressed by the guards, it simply does not give rise to an 8th Amendment violation. It could not possibly be argued that petitioners were reckless in this case. Recklessness is the conscious disregard of the creation of a substantial and justifiable risk.
What is the risk, though, that we're talking about? We have a respondent who has attempted to castrate herself. That is a risk, no doubt.
Yes, Your Honor, which is why petitioners took action and allowed her to sleep alone and shower alone and provide her with all of those other accommodations of wearing female undergarments, of continuing a cosmetic treatment, of body hair removal sessions, because they are aware that she does have a serious medical need. In addition to that, that is why they are providing her with the ability to sleep alone and shower alone, to remove her from any other potential risk that may be present towards her.
If she gets that surgery, is she automatically transferred to the women's prison?
Yes, Your Honor. And Dr. Putnam assessed against that because we have to look at the totality of all of inmates in the prison community in that specific instance versus just one. Additionally, Your Honors, in going back to recklessness, this is the risk that is present is the gender dysphoria. This was not a risk that was created by prison officials. This respondent was
Respectfully, whether it was created or not by the petitioners, it's something that's within the scope of their responsibilities. Does the government concede that?
Yes, Your Honor, which is why they took forth those actions in protecting her, because they are aware that the risk is gender dysphoria and the symptoms that come with it. But that risk came about when she was 15, when she was diagnosed of having gender dysphoria, Your Honor. That risk did not come about once she started prison. Additionally, Your Honor, in Farmers versus Brennan, held that prison officials cannot be found liable under the 8th Amendment for denying an inmate humane conditions of confinement unless the officials know of and disregards excessive risks to the inmate's health or safety. That case defines humane conditions as receiving food, clothing, shelter, and medical care, all of which respondent has.
Back to the original question by Justice Glover, is this life or death medical care? Meaning, if the respondent doesn't get it, are we risking death?
Your Honor, no, because several doctors in the medical community assess against sex reassignment surgery. Your Honors, I see that my time is up. May I briefly conclude?
Of course.
Therefore, Your Honors, by siding with respondent, it would lower the standard that this court holds in the Farmer versus Brennan case. And therefore, for the foregoing reasons, this court should reverse the decision by the 18th Circuit Court of Appeals. Thank you.
Thank you so much. For the respondent, Ms. Taviglione.
Good afternoon, Your Honors, Mr. Chief Justice. May it please the Court. My name is Ashley Traviglione, and I represent the respondent, June Osborne, in this Eighth Amendment action. Your Honors, this case is about a suicidal transgender woman who has been refused the only effective treatment to treat her serious medical need. Therefore, respondent respectfully requests this Court to affirm the appellate court decision and hold that there was an Eighth Amendment violation for the following two reasons. First, there was a serious medical need. It was diagnosed by a medical professional, and it can be shown through worsening anxiety, suicidal ideations, and even attempted self-castration. Second, that serious medical need was treated with deliberate indifference by prison administrators when they refused to give respondents sex reassignment surgery, posing an excessive risk.
The petitioner says you don't get to choose the medical treatment that should be provided. And they are not deliberately indifferent because they've done a lot of things. What do you say to that?
Yes, Your Honor. This is not about the preferred method of treatment. This is about the only effective treatment to save Miss Osborne's life. This court in Estelle defined deliberate indifference as something more than negligence, but something less than intentional. It is this conscious disregard for one's health and one's safety. And here there was deliberate indifference towards Miss Osborne.
I'm struggling with that with all due respect. That is, how were the petitioners deliberately indifferent when they've engaged in a course of ameliorative activity that has been described that's part of the record? We may not like the situation that respondent is in, but how is that the prong number two? That is Farmer, Kozliak, and Estelle. How does it inform us that the petitioners were deliberate in their indifference, and the word is reckless? They consciously disregarded the facts that they had.
Yes, Your Honor. Petitioners consciously disregarded June Osborne's health because none of the accommodations given to Miss Osborne are working. They have exhausted all options, and Miss Osborne is not any less suicidal. She is even attempted self-castration inside of her cell. And it was diagnosed by Dr. Nicholas Blaine that Miss Osborne is in need of sex reassignment surgery. Dr. Nicholas Blaine is employed
Counsel,
by
if I may, what about petitioner's statement that this time is really about moderating and understanding and appreciating June's treatment, and that this time is necessary before the next time? What do you say to that?
Your Honor, to opposing counsel's point that they need to wait and see how the accommodations are to Miss Osborne, this is a time-sensitive issue. This is a suicidal person. There is not time to wait on this matter to see how the accommodations will affect her. She is suicidal and could take her own life. This is a life and death situation.
Counsel, doesn't Kozliak fit this case like a glove?
Yes, Your Honor, while it is true that there are facts in Kozliak that resemble this case, Kozliak is also distinguishable to this case. And that is because in Kozliak, while incarcerated, the individual felt that the treatment options were no longer effective. But here, the treatment options were never effective. Miss Osborne is suicidal, and it is according to the WPATH, who are the leading experts in health and transgender illness, that when coupled with gender dysphoria is suicidal tendencies, the only effective treatment to cure gender dysphoria is sex reassignment surgery.
But isn't that disputed by Gibson? The medical data on that is not clear?
Not exactly, Your Honor. While there is a debate in the medical world on sex reassignment surgery, it is important to give deference to medical professionals. There are medical findings that show that sex reassignment surgery, when exhausting all other options, is the only life-saving option for an individual.
The opponent says we've not exhausted all options yet. She says we need to, this has been mentioned by my colleague, we need to moderate, understand, and in essence, assess the continuation of the treatment.
Yes, Your Honor, but as emphasized, there is not time to assess the evaluation of the treatment. As this is a suicidal person, she is a danger to herself. Miss Osborne has also experienced danger from others. As being put in Gilead Correctional Facility, she has been sexually and physically assaulted over 25 times, as shown by page 3 of the record. And Dr. Blaine assessed that sex reassignment surgery is necessary.
You mentioned we should give deference to the medical professionals. Shouldn't we also give deference to the prisons and their understanding of how to work with their inmates under those circumstances?
Yes, Your Honor. While prison administrators do understand how to work with inmates, this is not just a regularly incarcerated person. This is a person with gender dysphoria. And it is important to understand what exactly gender dysphoria is to understand the severity of the medical illness that June Osborne faces. And gender dysphoria is a serious illness that impairs one's proper functioning. And without effective treatment, Respondent poses a great risk to herself. And she is also, as emphasized, a risk from others. If Ms. Osborne was to receive sex reassignment surgery, she would be placed in an all-female prison where the threat of physical and sexual abuse would be diminished to herself. Therefore, in not placing Ms. Osborne in an all-female prison, petitioners are deliberately indifferent in creating a risk to Ms. Osborne. Your Honors, I would also like to point to the case of Edemo in the Ninth Circuit in 2019, a case that is relatively recent and the court should use as guidance as this follows the factors similar in this case. In the case of Edemo, Your Honors, there is a transgender inmate suffering from gender dysphoria. The gender dysphoria also was coupled with suicidal tendencies. And the court determined when all other options were exhausted and no remedies, non-surgical remedies, were alleviating the anguish felt by the individual, there was cruel and unusual punishment, and there was an Eighth Amendment violation.
But aren't the experts in dispute in our case before us?
Your Honor, may you please repeat your question?
Yes. The Edmond case, the experts were all had the same opinion, but here we have a split, right?
Yes, Your Honor, we do have a split in opinion here. However, we have Dr. Blaine, who is a specialist in incarcerated individuals in mental health, and then we have Dr. Putnam. It is not clear to the record why Dr. Putnam was brought in. On page 3, it states that she was brought in as a second opinion from time to time. Therefore, it can be interpreted to the court that petitioners did not like the available service of Mr. Blaine and decided to go with a second opinion that fit their political agenda. Your Honors, I would also like to bring attention to the case of Norsworthy. In the case of Norsworthy, in the 2015, there was also a transgender individual. And that transgender individual was suffering from gender dysphoria similar to Ms. Osborne. And the court ruled where there was ongoing anguish with that individual and what that individual was feeling, an Eighth Amendment claim was plausible.
Counsel, I want you to know where I'm struggling, and Judge Cohen hit the nail on the head, and that's the second prong and the deliberate nature that is necessary to establish. I'm really going to ask you to speak to that as you go through, your cases, because that's where I'm struggling.
Yes, Your Honor. And petitioners were deliberately indifferent to Ms. Osborne, as by the definition of deliberate indifference, and as Edmo tells the court, deliberate indifference is when you have a chosen course of treatment that is unacceptable under the circumstances, and you continue along that chosen course of treatment despite the excess risk. And here, given the circumstances of that Ms. Osborne has gender dysphoria, it is coupled with suicidal tendencies, and she is at a risk of violence from others, repetitive violence from others. That is deliberately indifferent because the court is the petitioner is aware of the risk that they cause, and they are not taking the appropriate course of treatment to diminish that risk. Likely, even after petitioners learned of respondent's condition, they continued to complicate her situation by allowing the guards to tease her. This diminished Ms. Osborne's health further, as shown by page 5 and 6 of the record.
Respectfully, the petitioner concedes that's wrong. I don't know how that helps your client, but they've conceded it's wrong. I don't know what measures they take, because we can't micromanage prison officials from the Supreme Court. But in the end, as Justice Glover is talking about, we're focused on how is this fitting prong 2. And I think we understand what the law is, and the law allows us to, in essence, focus on both objective and subjective prongs. And we are struggling over, at least I'll speak for myself right now, the notion of how is this deliberate indifference if all they're saying is, we've done A, B, C, D, E, F, and G. We want to continue along this course, and I think that's where respondent and petitioner part. But in light of the record, as Justice Tambasco talks about, we have a split among the experts. It's unclear that this is, quote, SRS, the only course of action.
Yes, Your Honor. And while there is a split among the experts, there is the WPATH findings, which are the leading experts in health and sciences for transgender individuals. And they state when all alternatives are exhausted, because there are alternatives to gender dysphoria, but when it is coupled with suicidal tendencies, when none of that is working, the only option left for this individual to save this individual's life is sex reassignment surgery. And it is quoted by Ms. Osborne on page 3 of the record. It is my genitals. I need them gone. This individual is in constant anguish when she wakes up every day and feels as though she is in a body that she does not belong in. Your Honors, I would also like to note that there was deliberate indifference among the petitioners because they created this excessive risk. When incarcerated in 2015, Ms. Osborne had expressed to petitioners her feelings of gender dysphoria. However, she was laughed at, she was sent back to her cell, and her cries for help went unheard. It was not until 2017, 2 full years later, that when Ms. Osborne attempted self-castration, that she was looked at by medical professionals for her serious medical need. Your Honors, this case is also like the case of Williams, because the case of Williams in 2018 stated that when other accommodations are not providing alleviation of gender dysphoria, it needs to have sex reassignment surgery in order to save an individual's life. Because as emphasized, this is a time-sensitive issue. This is a person that can take their own life at any moment, Your Honors. And the petitioners are beyond negligent. They are more than negligent because they are aware of the risks, as given they provided Ms. Osborne with multiple accommodations. And
So I want to make sure you have time, but I want to see if I truly understand you on the prong of deliberate. Are you saying that when none of your treatment works, this is now a life or death situation, and therefore it is deliberate indifference?
no, Your Honor. Respondent is saying that when,
Did you hear me? I'll repeat it.
yes, Your Honor, thank you.
I said, are you saying that when none of the treatments are working, that the prison is setting forth, in that moderate time that they're looking to engage in and watch June over this period, when none of it's working, this is a life or death situation, and therefore it is deliberate indifference?
Yes, Your Honor, and it has always been a life or death situation.
Okay, thank you.
Ms. Osborne is suicidal. She has expressed suicidal tendencies. She has attempted self-castration. And because this is a life and death situation that cannot wait for Ms. Osborne to be paroled, this needs to be addressed now, and Ms. Osborne needs sex reassignment surgery. Respondent respectfully asks the court to take into consideration the totality of all the circumstances, being that Ms. Osborne is suffering from gender dysphoria, being that she is suicidal, and being that there is a violence from others. Ms. Osborne needs to be placed in that all-female facility in order to diminish the risk against herself and the risk that others pose to her. Respondent is not asking the court to develop a bright-line rule here, but rather respondent is asking to look at the circumstances as a case-by-case situation and grant Ms. Osborne an Eighth Amendment violation because petitioners were deliberately indifferent to her needs, causing an excessive risk. Therefore, Your Honors, I respectfully request this court to affirm the appellate's court decision and hold that there was an Eighth Amendment violation. Thank you.
Thank you very much. Does the petitioner wish rebuttal? Yes. I think you have 1 minute.
I'm going to stop you before you start, if I may. I asked one question, and you know I was struggling a little bit on that second prong, so I'll ask you. If your treatment that you were speaking of, if it's not working, and it thus creates a life or death situation, does that then satisfy the second prong of deliberate indifference?
Your Honor, to establish the second prong of deliberate indifference would mean that petitioners would have to showcase a reckless disregard to the medical need of that respondent. So if professional doctors assess that this was the only absolute possible care left and petitioners were acting recklessly to that, then yes, it would rise to deliberate indifference. But that actually speaks to my point on rebuttal, Your Honor, that I would like to address if I may. Respondent relies on this court's case, Farmer versus Brennan, to reference deliberate indifference. However, Farmer versus Brennan holds a test of adequate care. If there is a serious medical need and a deliberate indifference to that need, then the care was inadequate. However, because petitioners provided medical care and accommodations that go above and beyond the standard of care that prisoners typically provide prisons, it does not constitute recklessness, and therefore the second prong was met and does not give rise to an Eighth Amendment violation. Thank you, Your Honors.
Thank you very much. All right. The justices will retire to deliberate, and court is now in recess. We will return.
All rise.
Good afternoon again, and everyone please be seated. I understand we had some technical problems with these sounds, so we'll try to speak directly into the microphone and as loudly as we can. I have judged many of these competitions over the years, and my colleagues and I agree this was the closest thing, 1 L's or even 2 or 3 L's. Look up this word, legal equipoise. What's equipoise? Everything should be a learning experience. It means close to even as possible. It sounds much more better, as we say, to call it equipoise. But it was one of the most difficult ones, I think we all agree, to make a decision. And we are first going to tell you who won because we want to put everybody out of their misery first. And then we're going to explain ourselves right after. We thought both attorneys were absolutely fabulous and excelled beyond really what we have seen in the past. But the winner was Miss Riano. And before we explain ourselves, that does not mean that that's the ruling on the law. We simply made a judgment that by what is almost 50-50, you were the most effective advocate for your client. Now, may I ask my colleagues if they would explain a little bit about what went into our judgment? Justice Glover.
There are no losers. Thank you, Chief Justice. There are no losers. Outstanding performance. Share with you what I always look for. I look to see how one pivots. I look to see how one pivots. For 1Ls, you're going to need this throughout law school. I'm class of '96. You're going to be asked questions and you're going to have to adjust because the rule is one way, but the facts weave in such a way that there's going to be either a pro or a con, and your job is that analysis. And your analysis is where you pivot. And my questions were geared to see how each of you pivoted when I would counter what you understood the law and the facts to be. and both of you were fantastic. It was too close really to call, but we had to make a judgment. I think that, you know, going forward for the 1Ls, you saw one of the best performances that I've seen in this experience. Last year was awesome too. Each year it's awesome, but both attorneys that were here were so well prepared, and one side, it appeared as if the law was a little bit more challenging. To get over that, in, you know, that second prong, that's a difficult challenge that you had to, and we honed in on it, and we challenged you on it, and you rose to the occasion. What I liked about how you rose is you didn't stick to simply the case law. You started moving to secondary sources and the like, and you didn't repeat yourself on that second prong. You continue to find different variations of why that second prong was satisfied. Kudos to you, because if the justices were asking me that question, I would sit there and go, asked and answered, man. I told you the reason. But you kept continuing with a series of reasons why it should be established. And to your point, you are so focused, laser focused, and your understanding of the brevity of the case law, as well as the facts, and you humanize the person as well, which is very difficult when you're really on the opposite side, and you embraced June, made June a person, and you were sensitive to that, so therefore it didn't seem like an institution against an individual. So kudos to you both, and congratulations, and keep you know, flying high.
Justice Tambasco.
Thank you. I want to just thank Coro for inviting me here today. Your experience here in the moot court competition, and for all of you, and whether it's mock trial or moot court, you're going to live with these experiences the rest of your life. You will pick up something. I graduated from law school in 1988, and I still remember from mock trial some of the points that were picked up and I learned at that time that I took through my career. And the same thing with this competition today. So it's a wonderful experience, and I encourage all the 1Ls to continue and participate in this in the future. Laura, you stayed on point. You addressed the questions that were put to you. It's not our job, but we try to throw you off at times, and you're able to think on your feet and address the questions that we put to you and pulling facts out of the record. Ashley, you were thrown a little bit, I think, in the beginning. You pulled it all together at the end. You had the more difficult argument to make today, and I think you did a terrific job. You focused in on some key facts and hit those hard in your arguments. So, again, kudos to both of you today. You did a terrific job. It's wonderful.
I will say that I graduated from law school well before my colleagues, almost 50 years ago. I also argued appellate court arguments maybe 250 times. Both of you could tomorrow step up and argue in our appellate courts, both state and federal, without any question at all. You've been trained well. The Moot Court Board did a great job today. And the training that it took to get you to this moment is absolutely fabulous, but so indicative of what Turo does for its graduates. 1Ls, this is literally the beginning of what you can do. And in simple terms, appellate advocacy, it's not trial advocacy. It is a very different technique. It is a very different methodology. And for both of you, the word is poise. You both had tremendous poise. You withstood, and I think Justice Glover hit it on the head. We ask off-putting questions. Sometimes they're actually annoying, and they may even be foolish. And in the end, the idea is not, hey, will you get off my back and stop bothering me? It's, you got to answer the question, and Your training was impeccable. Unflappable, you spoke clearly, and you were able to project your arguments when it came to your points of law. Again, you are both consummate professionals, and I understand we still have more legal education to go. But both of you are really to be commended, and this was for us a most difficult decision. So congratulations to you both, congratulations to the Moot Court Board, and of course, congratulations to Turo. This was a great, great exercise. Thank you.
I just want to make a pitch, because we are in Suffolk County, and I'm the president of the Suffolk County Bar
All
Association.
right, you're going to have to wait for the second pitch.
That you join the Bar Association. It is free as a student. I will say for many of you, I always wanted to work in Suffolk County. I had no connections whatsoever. I'm not going to bore you with the story, but my joining the Bar Association, even though I was working in the city, it helped me later in my career. And I've been working the lead counsel for Geico in Suffolk County since 1996. And that's in part from the Bar Association. So make those connections, join. Don't overlook the importance of that. There seems to be a lot of discussion among attorneys that younger attorneys don't appreciate the personal connections that you make. And I just want to tell you they are important. They are very important. So that's if I can leave you with that, please join the Suffolk County Bar or Dorian for the Nassau County Bar.
If I may, Judge?
Yeah.
I adopt, based upon brevity and this time, I adopt all of the comments by President Tambasco. Just want to share with you, I'm the first president of the Nassau County Bar Association from Toro. I joined as a 1L. Why? It was free. I shall repeat, free. And the benefit from being around judges, we have, a catering facility, we have continuing legal education, which is part of your dues, which is free for you at this point. But the interaction, and you cannot get where you wish to go in life without the ability to network and to meet distinguished individuals. So regardless of which bar you choose, do choose a bar. Nassau, Suffolk, New York State, Amistad, Long Island Hispanic Bar Association.
Join all of them.
Join, but be a part of it. And I look forward to welcoming you to Nassau County as you join the Nassau County Bar Association.
I will only add, I have no dog in this fight. However, law students, especially in the age of the pandemic, might say, gee, do I really want to get involved with them? Do I really need it? You remember this Dr. Seuss book when you were kids, or The People You Meet? The only way you meet people that are going to be professionally important for you is at the bar associations. And these bar associations, without saying anything more, happen to be exceptional. They both have academies of law that are literally educational institutions. And to enmesh yourself with lawyers, judges, and professionals is really something that enhances your careers. So I urge that you do that, and I'm a member, not of Nassau, but I belong to Suffolk, and I've been a member at least 45 years. And so it's an honor. Thank you all very much for a great afternoon.